Hello students, welcome to AKS. In this video, we'll continue our discussion on fundamental rights. We will start with Article 22 of the Constitution. Article 22 of the Constitution. What does this article state? It states that it includes the safeguards to protect people from arbitrary arrest, and detention. Okay, so it also includes some principles of natural justice. Arbitrary arrest is the arrest without a specific ground or an arrest warrant, and thus it violates Article 21, that is right to life and personal liberty. So you're arresting a person without any specific ground or any kind of violation of the law. It means that you're inhibiting his personal liberty. So this Article 22 provides safeguards in the form of one. A person shall be informed of the grounds of his arrest. Number two, a person should be produced before the nearest magistrate within 24 hours, excluding the time of transport. Number three, a person who is arrested should be given an opportunity to consult a lawyer of his choice to defend himself in the court of law. So these are the various safeguards provided to a person who has been arrested. So please note that Article 21, Article 22, and also Article 20 is available to both citizens as well as non-citizens. So these above safeguards which we discussed, that is, the right to be informed for the grounds of his arrest, the right to appear before a magistrate within 24 hours, the right to consult a lawyer, are the safeguards available to a person for arrest under ordinary law, ordinary criminal offense, but not under preventive detention. So there are two types of detentions, namely preventive detention and punitive detention. Under Article 22, people who have been arrested under preventive detention also have some safeguards. These are the above ones which we discussed are the safeguards available to people arrested under ordinary criminal offense. For the people arrested under preventive detention, there are some safeguards to Article 22 which we will discuss. Please note that detention is of two types, namely punitive detention and preventive detention. What is punitive detention? Punitive detention is a detention after a person has actually committed an offense. That is, you punish a person for an offense committed by him after trial and conviction in a court of law. What is preventive detention? Preventive detention is one where detention is done before a person has actually committed an offense on the assumption that he is likely to commit an offense, and the detention of a person before a trial in a court of law or conviction by a court. Preventive detention is a concurrent list subject. Okay, thus both the state legislature as well as parliament have the power to make laws on preventive detention. So for the parliament to make a law regarding preventive detention, there are various grounds, such as in the union list they have been mentioned. That is, when there is an offense committed against the defense of India, when there is an offense which affects India's security, when it is affecting India's foreign relations and affairs. So the grounds for preventive detention are present in the union list. So the state list cannot make laws on the above three subjects regarding defense and security of India and regarding foreign affairs. The state legislatures can also make laws providing preventive detention on the grounds. These are some of the areas mentioned in the concurrent list, and thus the state government as well as the parliament can make laws. That is, for the maintenance of public order, for the security of the state, and for the maintenance of essential commodities that has been, for example, you have ESMA Act, Essential Commodities Maintenance Act. So ISMA Act can also impose preventive detention. So these are the subjects under which the state governments can also pass preventive detention laws through this concurrent list subjects. So what are the safeguards mentioned in Article 22 regarding preventive detention? When a person is arrested under preventive detention, the grounds for his arrest have to be informed as early as possible. As early as possible. That is, there is no time limit. That is, when a person is arrested under preventive detention, with a preventive detention, there is no arrest warrant. Okay, but this Article 22 says that the grounds for his arrest shall be informed as early as possible. And number two, the person has the right to consult a lawyer, and also the person cannot be detained for a period more than 3 months. Okay. If a state wants to detain beyond 3 months, then an advisory board has to be consulted, constituted with a serving judge of the High Court as its chairman. And if the single member advisory board recommends to the state to extend the detention, only then that the preventive detention of a person can be extended. The recommendation of this advisory board is mandatory for the state to detain a person beyond 3 months. When Parliament makes a law providing for preventive detention, it itself makes it possible for a person to be detained beyond 3 months, then the advisory board's recommendation is not necessary. So, some of the laws which provided for preventive detention are National Security Act 1980, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, Coffee Posa Act, and also TADA, POTA, POTO, etc. Okay, so these are some of the preventive detention laws. Thank you.